welcome everyone to the second episode of the Oral History of Data Protection Law. This is a collaboration between the European Data Protection Supervisor, the EDPS, and we are here at the EDPS, and the Law, Science, Technology and Society Research Group of the Free University of Brussels, VUB. Now, I am the director of LSTS, the research group at VUB. I'm a professor at VUB, and I'm very, very, very glad to be part of this initiative. I'm very, very glad today to be here with a legend, an institution. I think you're an institution metaphorically and literally, because he was the former European Data Protection Supervisor, Peter Hustinx. Welcome. And
Sure.
we are not just on our own here. We have another special guest that will also participate to this talk, and this is Herke Kranenborg. Welcome. He's professor of European Data Protection Law and Privacy, or European Data Protection and Privacy Law at Maastricht University. You're also a member of the legal services of the European Commission. Welcome. So we are here to discuss your work in general, but we will focus very much, in part, on Convention 108 and the negotiations that led to Convention 108. So trying to go back in time and really explore this part of the history of data protection law. To situate the audience, because we know a little bit about you, but not everybody knows everything, Herke will briefly introduce us.
Thank you, Gloria, and thank you for inviting me for this special interview. Indeed, we have a legend here. I'm very happy with the series you are recording here. I think it's an impressive piece of work and also of importance. Do I actually need to introduce Peter Hustinx to the audience? I don't think so. He's very well known, maybe one of the big leaders of the development of European data protection law in the from scratch, actually, and that's what we will be talking about today. People know him in particular as the first European data protection supervisor. He has been supervised for 11 years in the end, so 2 full terms. But what people perhaps know a bit less, although they had suspicions, but he has been involved on almost every element in the development of European data protection law. But he has been for long also the president of the Dutch Data Protection Authority. Not only the one that was based on Directive 95/46, but even the one before that. So for a very long time he has been already supervisor at national level. And before that, so in 1971, you started working at the Ministry of Justice, and in that capacity you have been active also in the development of the Convention 108, which also shows that you have a lot of, you don't have a national view, but really took and still take an international view. And I was sort of looking up a book which was created for you by many people when you left DDPS or when you were in office for 10 years. And there is a preface of Mr. Redding, the former Vice President of the European Commission, who was, of course, one of the big drivers behind the GDPR. And she, of course, speaks highly of you, but she says it's difficult to overstate Peter's contribution to European Union policymaking on data protection. He has played an instrumental role in establishing the European brand of data protection as a global standard. Spread over 5 decades, and that was in 2014, his service to the cause has bridged all possible levels of activity, national, European and international. And I know that since 2014, you have still been active in the area up till today. So we are now up to 6 decades. I think it's very rich, a rich career, impressive career, and it's of course wonderful to have you here and to hear about your experience from the early days. So welcome.
Right.
Yes, so we will start with our questions, and we would like to go back, perhaps not to the childhood part, unless there is something that you want to share with us. But I was surprised by looking at your biography. You studied in Nijmegen in the Netherlands, but then you studied also in the United States. And I don't know how common that was at the time. Was that common, and why did this happen? How did you move there?
Well, there was even a step before that, Gloria. I was lucky to have received a junior Fulbright scholarship before university. So I spent 1 year at an American college, Dartmouth College in New Hampshire. And during that year, actually, I decided not to go to chemistry or medicine, but go for law. And during that year, I took a deep dive in American history, in what was called government, but basically principles of constitutional law, and American culture in general. And it fascinated me, and I decided I should not spend my life in a lab. Now, on that basis, and it was very challenging, very, very, very impressive, the interactive way. So I was eager to see whether something similar could be repeated in law school. And Michigan is actually a stronghold of European law. That was not the main driver, but it was an added value. I did comparative law. And during that year, and that's very relevant for today's conversation, I was also exposed to the very first thinking on privacy and computers. We were all brought together, foreign lawyers, in a summer school before, and one of the teachers was Arthur Miller of Harvard, but previously of Michigan, who had just published a book, Assault on Privacy, and of course he spoke about this, and we discussed this. And there was also then a reason to take a seminar, a side seminar on computers and the law on computers and computers in the law, both. Ranging from symbolic logic to administrative purposes, and privacy was part of it. So when I came to the Ministry of Justice, and you haven't touched on that, and I've been hired before the US, okay. When they discovered that there was some exposure to computers, they said, "We need you." And that had consequences.
Just a little question. When you were in the United States, were you the only European?
Oh, no. The summer school at Brown University in Rhode Island was about 200 foreign lawyers from all over Latin America, China, Europeans, quite a lot of Europeans, also Dutchmen, Belgians, Frenchmen, etc. And in Michigan, I think we were maybe some 20 foreign lawyers. But the whole environment was very impressive, challenging, huge assignments for every meeting, every class. But then the question was, this was the case, but what if the case would have been different? What do you think? And then you better had an answer. So there was no way to hide. And I found this fascinating. And I discovered, the value of this interactive education.
So you mentioned that they were looking for somebody who knew about computers at the Ministry of Justice in the Netherlands. Was there a particular reason why the Ministry of Justice was so into data protection and computers at that moment of time?
Not at all. Not at all, to start with. In fact, criminal law had been updated on hidden cameras and wiretapping and things like that. And in 1969, it's a long time ago, the then Minister of Justice said, so everything is now up to date. But the next year was a census every 10 years. And that developed into a big, big problem in the Netherlands with about almost 500,000 people refusing. For two reasons. It was the government reaching out, and that was in the cultural environment of around 1970, 71, a big thing. And for the first time, computers. So there was also talk about a personal number. So there were big symbolic issues. Computers at the time were just heat-producing machines, so-called, and we had punch cards. So it was far from the present, but it appeared on the screen as something relevant. And the new government, which had started in my absence, I was in the US, I didn't participate in this, had said, we need legislation to protect our privacy. So in the first weeks, literally, of my junior work as a legal advisor, they were preparing for a commission to advise on this legislation. And so I was appointed before Christmas, entering in September, before Christmas, as one of the assistant secretaries to that commission. And that was just thinking from scratch.
And how did that, because of course this, I think quite quickly there was realization that this was a bigger problem than only for the Netherlands. In how far did this international dimension immediately kick in, or was it first of all a national
Very soon.
Dutch discussion?
It started off as a national issue. And of course, so a commission like that has the virtue of bringing a solution eventually, but also postponing the problem. And there is a lot of also not in my backyard kind of problem. It's important, but don't touch the banks, don't touch the insurance companies. So it took about 40 or 50 meetings. In the meantime, we were working, and we were visiting Sweden, particularly because there was some interesting work there. But in 1972 or 3, I was sent to meetings in Strasbourg because the Council of Europe had started on the subject as well. Now that was the first time was to plead a case before the Commission on Human Rights, which then existed, about criminal law. But the discussion in Strasbourg was about the very first recommendations. And they have been adopted by the Council of Ministers, I think in 73 and 74, on the private sector and the public sector. And there you see this was more or less natural extraction from what was available, Sweden, Germany, and some international thinking as well. Coming back to the US, in parallel, but not connected, there had been Watergate. There had been an important driver in the Senate pushing for a US Privacy Act. There was an interesting report of the Department of Health, Education and Welfare, which for the first time set out the fair information principles, the so-called FIPS in the jargon, which were used in the discussion in Europe as well. So there was fundamental right thinking, but there was also common law thinking in parallel, and it influenced each other.
You explained this, and for me it looks like everything went very quickly. You were studying.
Well, yes, it took years, huh? So
yes.
I started in 71.
Mm-hmm.
The first recommendations, and there's committee met, I think, twice or 3 times a year, so it was not overly burdensome. But the endorsement by the Council of Ministers of those recommendations happened quite easily. Although the public sector recommendation, of course, also faced the issue of exceptions to the principles. And that was then preparing the ground for a possible convention. And you see in those first recommendations in 73 already preceding a possible convention. So the idea to do more was there. And it was Frits Hondius, the key person in the Council of Europe, who played a key role in this.
So perhaps if you could tell us more about Frits Hondius. He was a Dutch national working at the Council of Europe?
That was a coincidence that he was a Dutchman. But we met during those discussions in Strasbourg, and I was very junior to him. I think he was in his 40s then. I don't know what he has been doing before joining the Council of Europe, but I discovered that he was appointed there in 69, I believe. And when we met, he was head of unit public law. And in this work, he was assisted by Lawrence Early, who later made it to the Registrar of the Human Rights Court. Fritz Hondius published an interesting book during a study period in Oxford, Emerging Data Protection in Europe, and you see how early it all was. He described national developments and then also fantasized about possible future. But when we met in Strasbourg, and the same applies to the other delegates from practically all member states, they had the same role in all those countries. They were all trying to invent the wheel. And if you do that separate, it's a problem. But if you do it together, it's fascinating. Because you ask questions. Why is this so obvious? How do we come there? And important for our present understanding is also that we were keenly aware of the fact that we were operating sort of in the wake of the Convention on Human Rights. The connection to privacy was obvious, but it was not necessarily within the scope of the right to privacy. In fact, it was between 8 and 10, the freedom of information. We were dealing with floating information. So the concept of data protection was developed in a way to build a bridge to do something in addition to Article 8 and Article 10. There was a close connection to 8, but it was something, a balancing act. And if you now look back, you see that some of the key elements of the convention, the notion of purpose, the notion of necessity, the notion of safeguards, the notion of balance, fairness, comes back in the convention when we developed it.
So we're slowly moving into the convention, but
Yes,
before we get there, you explained these two recommendations, which on the one hand cover the public sector, on the other hand the private sector.
Yes.
And you mentioned in the Netherlands this census. In how far was this private sector recommendation an issue? So, because I can imagine that in the beginning it was all about the public sector, how the government could use computers.
True.
So how did this kick in the discussions?
Well, frankly, I think Strasbourg started with private sector because it was easier. For the reason I mentioned, the public sector principles is fine, but there are, of course, huge exceptions. And then you enter a difficult field, and you deal with taxes and fiscal authorities, but criminal investigations and Secret Service and whatnot. So maybe leave that for a later stage. But I was not involved in the decision of where to start. I was sent there, and in the first meetings, you smelled in the meeting, but also outside the meetings, over coffee and dinner, that this was new. It was fantastic. And it was very inspiring. And quickly, we were discussing principles, whereas the discussion in the Netherlands was more about procedures and distinctions at a higher level. Huge field. How do you draw lines? So the Swedes were thinking in terms of licenses, license, either general or specific. Germany was from the very beginning thinking in terms of basic rules, general rules. The Brits were there with fairness and reasonableness. France was there with everything fine, but we need good institutions to be in control. So there was a bouillabaisse of. But of course, you needed some authority. The Council of Ministers said, Okay, go ahead with the convention.
Of course, when you bring in the private sector, that was a huge difference with the American perspective, because in principle, they were not that interested with the Privacy Act. They were not interested in regulating the private sector, because we have not really mentioned trans-border data flows, this issue which became very important for the United States. Was that discussed already then at the Council of Europe?
Also back, of course, the US Privacy Act deals with the federal government, and that was the only way. And it deals with public sector, therefore. But if you see the documents, it also led to the adoption, to the establishment of a study commission to do more, the US Privacy Protection Study Commission, something like that. And the report which they published in 76 or 7 covers a wide field. And until the middle of the 70s, the US was following a similar course, private and public. And don't forget, the states, and some states are now also quite eager to deal with privacy, are having private sectors, obviously. I remember one conversation in Washington, and I've been back and forth since to my law school and friends and so. Not every year, but quite frequently. When our government commission had published its final report, and I shared those main lines with the secretary of the US Privacy Study Commission, the late Ronald Plesser. And he said, gee, we would need, this is very far-reaching, you're doing. We would need a much stronger rationale. This I have kept in mind, and it landed with me. I said, why is that? Well, the First Amendment, and so forth and so on. So that the different approaches were clear to me. I had my background, and I got his input. And after that, that report was shelved. That fine report, it's about, in various volumes, this thick. President Reagan introduced the market. You know, everything was built on the market. Now, far ahead, in the 90s, they discovered, under Clinton and Gore, who had invented the internet, Gore had invented the internet, but they discovered that the market could not provide for some solutions. So the US were going for self-regulation, organized self-regulation. Well, all these elements had been part of our discussion in the 70s.
So now we do turn to the Convention 108, I think. And of course, we are eager to know, first of all, perhaps the atmospheric impressions you still have from that period. How was the atmosphere? You already mentioned that you were working on something new.
Yeah.
So there was a certain spirit, I guess. Yeah. But were there also certain tensions, or because it's, of course, it's nice to link it to human rights, and it's under the heading of the Convention on Human Rights. But there is, of course, a big economic interest and a data flow interest, which is perhaps the real interest to regulate it at an international level.
Yeah.
So what was the atmosphere?
Well, the atmosphere was certainly not tense. There were some tensions, and I'll come to that. But in general, it was very relaxed, and it was discovering new territories. Again, we were not operating within the scope of convention. Partly, yes, privacy, but the sense that personal data in general quite often simply escape the scope of according to the thinking then. But from the beginning, the committee of experts was set up with observers from the OECD. So there were already early connections, and Frits Hondius was the personal connection. He was also a member of the activities in the council, in the OECD. And there were some observers from some main countries, member of the OECD, the US, Australia. They don't show up every time. But I remember when we were well on our way, all of a sudden, the US delegation was presenting an official note reading that this exercise was an obvious breach of the Helsinki agreements. Helsinki agreements. That was an agreement between the West and the East, where the East, the Soviet Union, was ready to accept certain fundamental rights, and the West was ready to accept the status quo, simply put. So referring in Strasbourg to a breach of the Helsinki agreements was tough language. We said, wow, this is from another planet. They're totally disconnected. And we did not pay attention. But it was amazing. A few years later, the OECD started to do a parallel activity, which ended up into the privacy guidelines. And Michael Kirby has been in your program. But by then, we had, in the convention discussion, more or less agreed on the hard core, the common core, including questions of scope and the architecture of the convention. And in the discussion on the hard core principles, the connection between, so the relevance of a legitimate purpose was obvious, then the relevance, necessity, current language. But there was some talk about what about the use of the data? Now, if the purpose determines storage and no longer retain than necessary, what's the flexibility in? We came up with not incompatible, which was designed to provide some flexibility. We didn't go into the details what the criteria were, but if you now look back, that flexibility is crucial. And that was discovering a way. Coming back to the, if I may, to OECD and Council of Europe. Council of Europe was heading for a convention, not a European convention, but an international that was determined, so open convention. It was a really far-sighted decision. OECD came up with a guideline for reasons Michael Kirby has explained. And they are quite consistent, but there are two crucial differences which probably go unnoticed to many. The first is the role of risk. Risk was hardly discussed in the convention discussion, but it was crucial for the OECD, and the document still says this applies only when there is a risk to privacy. So risk as a threshold condition, which is not human rights thinking, but it's still relevant. But it means this is left to member states. And more crucial, even, you don't find the idea of a legitimate purpose in the OECD. Purpose, yes, and it should be relevant for the purpose, and it should not could be collected with unlawful means, unfair means, and where appropriate, with consent. But legitimacy for data processing was pushed back. Whereas in Strasbourg, this was crucial. And still is. Legitimacy is a key question. Legal basis, etc., etc. So that served the purpose of the non-European countries, and perhaps wisely so. It has allowed them to develop their own laws, which now are remarkably consistent to the extent they exist. In the case of the US, it's taken 4 decades to sort of come closer. But now you see in California and a dozen other states, bits and pieces of European sort of GDPR light, including the right to be forgotten, which was a provocation in the in the eyes of the Americans when it was mentioned in Brussels.
Just one follow-up question, because it's fascinating how you describe how the US tried to influence the debate. You see the right to be forgotten, you just mentioned as a...
Which, of course, came much later. But
Yeah, but what was their main concern? Because it's of course fascinating that still today, because you talk about convergence now and both sides of the Atlantic growing together. But I have the feeling that at the moment we are at a point that Europe is more or less asked, in particular, for instance, on this risk-based approach, and then in particular in relation to third country transfers, to perhaps converge more towards other third countries, perhaps the United States. So I recognize the attitude of the United States still today, but it's fascinating to hear it was already there at that time.
Looking back over, say, 40, 50 years, it strikes me that we've seen the principal approach drifting west to the US, and they have landed. Initially, they were, apart from the very early principles, the FIPS, there was chief privacy officers, so internal governments in companies and also in government. But the principles have drifted west, and some of the practices have drifted east. Our privacy data protection officers are American or Anglo-Saxon vintage. But that was in retrospect, this convergence. Of course, there are huge differences, and there still are. And in the 70s, what was driving the Americans to be concerned about these Europeans, and probably commercial and technical. And the big companies we have now did not exist yet. IBM did, but the others did not. And telephones were fixed to the wall and never in your pocket. Internet did not exist. So this discussion was largely about office machinery and banks and insurance companies, plus telephone, maybe. That world, but it started to become very dynamic in the 90s and beyond. And of course, in the discussion now, the US, Silicon Valley, has huge stakes, and we know the names. As EDPS, once I gave a lecture at Silicon Valley, and I said, you need to innovate better. You think you're good in innovation. You're not. You need to innovate privacy-enhancing technologies. You need to innovate privacy. Oh. That was an interesting discussion we had.
So, leaving for 1 second the United States and coming back to Europe, you mentioned before there were like some different ways of thinking or different approaches. Were there also eventually real tensions in the negotiations? Because I think the French were like most vocal in this opposition against the United States. I'm not sure everybody was on the same line.
Well, Louis Journet, and Michael Kirby mentioned his name, but I remember Louis Journet as the French delegate who also acted as the chairman of the committee of experts for 2 years. He was full French style, but he was not the only firm participant. Of course, in fact, everyone thought that this is natural, that his own legal tradition was the best way forward. So asking questions, how things could be seen from a different angle if you came from Austria or from Italy or from Spain. Spain did not, I'm not sure. Of course, eventually. But okay, different, that leads to interesting discussions. But tensions, again, maybe I'm idealizing, I don't remember really tensions. And by 78, the convention was almost ready. The additional 2 years were spent on 2 difficult issues. And that was just very difficult. And the one is transborder data flow, the international dimensions. Is there any need to have provisions on this? It was not obvious in the beginning. and the way in which was not obvious. And the second, even more complicated, was applicable law. What law applies when and where and to what extent? And while we gradually moved into a direction of what came out as Article 12, first style of the Convention 108, applicable law was never solved. There was a formal request then sent via Frits Hondius' team to the Hague Conference of International Law. And I think the answer we got was, oh, we have other priorities and it's too difficult, maybe. So it was left. And applicable law is one of those things which the directive, the EC directive, introduced, and which, of course, leads to another discussion. But that was then given up, and on the basis of the Convention 108, as you are aware, the Council of Europe continued with almost every year another recommendation specifying those principles. And the notion of what are personal data was only then looked at more carefully. Identifiability, what does it really mean? And which is my hobby horse, the question of when does information relate to a person, leaving aside whether that person is identifiable or not. All that thinking was in the course of the 80s. And in fact, identifiability overshadowed the discussion. But how does it apply to research? Spiros Semitis, a name I should mention, is gone. Spiros did not participate in the Convention 108. He participated on and off in Paris, in OECD. Of course, meanwhile, he was commissioner in Hessen, in Germany. But he was for sure a giant in terms of intellectual force, and he became the first chairman, not the first, the second chairman of the Committee of Experts in the 80s. And we worked closely together, and I succeeded him when he stepped down. Spiros, oversaw the development of the recommendation on scientific research and statistics, and then we've seen, well, a list, a dozen. And end of the 80s, I no longer participated in Strasbourg, and then we had the Dutch chapter.
So Convention 108 laid down the basic principles. You're basically saying, and later on this was given flesh through further recommendations by the Council of Europe. Still going back a bit to the negotiations, because you mentioned that every country brought its own culture into the debates and its own approach. I don't hear you say much about Germany, although Germany is broadly understood as being behind the protection of personal data, or big driver behind protection of personal data in Europe. Were they indeed also so present in that debate at the time and imposed or put forward their thinking on data protection?
Yes, but they were, for sure. But it was also quite controversial subject of data protection. And don't forget that in the 70s, there was also a problem of terrorism in Germany. And the Ministry of Internal Affairs, being responsible for data protection, had another portfolio as well. So there were different schools in Germany, ranging from data protection law is basically traffic law for information, technical traffic law. It's not very respectful, but I think that word was used. And the other was informational self-determination. But the case which set out the right to data protection as the right to self-determination was decided in 83, I believe, in December 83, after the Convention 108. So self-determination was never an element in the discussions. The Germans did not invoke that right. Of course, we knew the German constitution, the value of human dignity, yeah, and all that. But that was not as strong as, it was much more, the principles in general, institutional emphasis from the French. And by then, some countries, France, Austria, and certainly Scandinavia, and some, and of course also, yes, the Federal Republic had their own legislation, and they had different emphasis. The German law laid down general rules, stronger rules for the public sector, and much more flexible rules for the private sector. The French basically laid down some beautiful principles, set up a commission of 17 members, and the commission should do it. The CNIL still exists. And still, Convention 108 doesn't speak about independent supervision. The first version did not contain independent supervision. There was appropriate arrangements for implementing this. And only when the EC directive introduced independent supervision, of course, it was amended, and both on transporter data flow and about independent supervision. So there has been in history, the European Commission has used Convention 108 as a starting point, specifying legitimacy, for instance, adding new elements like independent supervision, and they were then used back in Convention 108 plus.
Just one follow-up question on this.
Please.
But you were actually quite junior at that time when the convention was negotiated. What was the Dutch print on this? What was the fingerprint of the Netherlands on this Convention 108? Is there a particular issue you remember that you were the one who proposed the compromise language or put forward an idea which really came from Dutch experience?
Well, the formula "not incompatible with" was taken literally from the guidelines we developed in the Netherlands in the early 70s. Then the idea was this commission is going to work and it will take some time, but in the meantime we do self-regulation. But self-regulation completely at random is not a good idea, so we should lay down some guidelines. And there was the Prime Minister's guidelines. And that has set actually a tradition of self-regulation in the Netherlands as part of the legislation. Self-regulation to avoid strategic use of self-regulation, but this was regulation to implement, to actually also introduce sectoral specifications. And that made it to the directive, as you are aware, self-regulation. So, but no, the principle in Convention 108 maybe not incompatible with. I was junior, yes, but of course, experience grows step by step. And so by the end of the 80s, I had quite a few international. I dealt with this for 20 years, 15 years.
I have the feeling that you really were always active at the Dutch level and at the international level, perhaps in different intensities?
Well, I should mention, just for the record, that we're discussing data protection now, but my role in the Dutch ministry this was one of the subjects I dealt with. I basically dealt with criminal law and constitutional, and I've done some other interesting subjects. But the red line, in retrospect, certainly were data protection. And this developed in all directions.
So you were working at the Council of Europe after Convention 108, as you mentioned, over the 80s?
Yeah, alongside.
Yes.
It was just 4 times a year, basically, a short week, 3-4 days in Strasbourg.
But at some point you left the government and you went to the other side?
I did not leave the government then. The work was done, and the national law took an awful lot of time. We had 4 different drafts before finally, after deregulation and making things simpler, etc., the law was adopted and entered into force. Then I closed my files, and a big relief, and it was moving on to another subject.
To the same subject?
Yes. Another subject, I thought.
Yes, explain.
But, well, the first president of the Dutch Data Protection Authority resigned 2 years hence. And so then the ball rolled back to me. And now, maybe it sounds a bit unparliamentary, but there were some early children diseases, teething problems. So they said, you solve the mess. And I wondered whether it would be a good idea to do that. Decided that I should continue, and it was fascinating. But it meant that in the appointment as National Privacy Commissioner, we had a board of 3, but I was the chairman, coincided with the Dutch presidency in the EU Council. And there, the Commission had recently, in 1990, I believe, presented a draft directive. And so in my first month as commissioner, I was also asked to chair that negotiation in council. And when that was finished after 6 months, there was a natural development of being the coordinating point of the European commissioners. We also organized the first European conference in The Hague. So, yes, so it all, and the 29 group later on, so forth.
So, because you became eventually the chair of the Article 29 Working Party. Yes. That's for our younger audiences, the predecessor of the EDPB. But you were never disconnected from this international. Already before, as you mentioned, there is an international.
Off and on, but I've been following this, yes, from the beginning.
And I really wonder: is that easy to be following at the same time being because you were still the chair of the Dutch Data Protection Authority, having these responsibilities at the European level? Is this easy? Is this manageable?
Was it easy? It was easy to combine, and yes, it was. It was, of course, it was hard work. But if you have a good team, and you give good guidance, I mean, you don't need to have to do everything yourself. That's the shorthand. But the second is that the issues which we were dealing with as regulators were actually also new, and all colleagues in various countries were dealing with similar issues. So comparing notes or doing joint exercises was also a very productive way of solving problems. And rather than inventing the wheel, and so the same mechanism of the discussions in Strasbourg were repeated in the context of the European Conference, which has been meeting as a spring conference ever since the 90s. And so you met all your colleagues, and it was also, yes, it was very inspiring, and it helped us to deal with the problem. Gradually in the 90s, some of those issues were overwhelming, called internet. And if you do not work together, then you're not going to be successful.
Do you ever reflect upon that period with colleagues from that time still and think back at it? Because at the time, as you said, it was all new. Now, if we look back at what technological developments you were looking at, it's of course very rudimentary. But do you ever look back or chat with these people and to say whether how surprising, but how special it actually is that these principles of Convention 108 still resonate while we are now talking about AI development, etc.
Yeah.
And how do you look back to it? Was it really the right way to go for Europe, you think? Or do you think perhaps some things should have been placed differently already at that time?
That's a double question. First, discussing, you mentioned I was very junior when it started, meaning that by now quite a few of the colleagues are no longer available to discuss. But for instance, with Spiros Samitis, who I developed a good friendship with, and also we shared a common interest in US. He was a guest lecturer in Yale, for instance, and so we met at both sides of the ocean, and I remember quite a few discussions with him. Also, he was a very strong proponent of this informational self-determination approach, which I don't want to be disrespectful, but I have always found a bit overstated, and I still think so. It's an overstatement to make a point, and the court itself in the 80s says, okay, this goes not without conditions, etc., and the nuances comes later on. But influence by data subject is important, but it can have different shapes. And so I see the data protection more as developed as a system of checks and balances, consisting of principles, rights and principles, procedures, independent oversight, which is influenced by the context. And sometimes the context is more requiring and demanding than in other states. So the flexibility is part of the system, the way I approach it. When this was then codified in the charter, that's obvious from the documents, it was to ensure the continued, say, the acquis of the directive, and also Directive 95/46 sets up a system of checks and balances, a system at least. Now there is increasingly a tendency to see the right to data protection as something which is, like privacy, a shield, and the language of the courts is interfering with data protection. Whereas originally, what is interference with its system of checks and balances? That if you interfere with its functioning, so if you interfere with the essential characteristics, if you say, okay, no independent oversight, purpose irrelevant. But okay, discussion with colleagues. But looking back at the developments and being fascinated by this whole line of development, yes. Have we done everything right? What strikes me most of all is the degree of continuity. Degree of continuity, in spite of all changes, technological change, the punch cards, the big thing. But we were aware in the beginning that this development would have enormous consequences. You can find that in the explanatory memorandum to the convention. That is, this was actually, we were thinking of proactive and structural safeguards, but would have large consequences. But the internet, of course, did not exist, and nobody could imagine it. And the tension about the use of information once gathered is key. We still struggle with it. And in my view, that struggle is very healthy. We should not solve it by saying, forget it. And the idea of not incompatible with still is visible in GDPR, with their exceptions, provided that, etc., etc. And that's healthy. And making developers and responsible controllers think about limits is very healthy. That's very good for a system. Don't make things too easy.
You discussed many points that I think we will love to discuss for many hours. You discussed the question of the right to data protection, but I have a little provocative question. You mentioned a number of important people from the past. You didn't mention Stefano Rodotà. Perhaps it's just because you cannot mention everyone, but I suppose you met in many different contexts.
Yes, but Stefano Rodotà, I know, made some contributions in Paris, but he did not participate in the discussions in Strasbourg. In fact, he came to the Article 29 working group only rather late. Italy did not have a law until 1998, I believe. And when he came, he became vice chair. And of course, he succeeded me as chair of the 29 group. And of course, his political contacts, both in the European Parliament and elsewhere, were extremely valuable. And of course, I know he did a fantastic job in Italy. And Giovanni Buttarelli, his Secretary General, was my deputy at some point and my successor. So yes, but no, he did not participate in. There was someone from the Ministry of, or a judge from somewhere, but Italy did not play a key role in the discussions.
Interesting. Yes, trying to now move to the almost here. So you were the chair of the Article 29 Working Party, and eventually you became even more connected to Brussels by becoming the first ever European data protection supervisor. I don't know if you want to just give a bit of background of how did this happen actually, that we understand. You applied for this position, which was really a novel position.
Yeah. Well, I was Dutch commissioner appointed in 91. Okay, so after 20 years of the Department of Justice, this was a next step. All in all, I think 12 years in that job. The EDPS vacancy came, and first I wondered whether that was a serious proposal. You know, what it entailed, what it meant. And I checked with various commission officials and said, is this serious? What is it really? And when I studied the regulation, I quickly discovered there was supervision, obviously, there was advising, 1 or 2 small articles. But with my background as a legislator and I knew how the political system worked, I thought that is an important thing to develop. It was cooperation with colleagues. Okay, that's another opportunity. And very importantly, there was the possibility to intervene in court cases. Now, on the job, the advice I got from our lawyers was, you should try, but it's probably not binding because other institutions have tried to intervene. And of course, you don't bring in a case, but you can request to be admitted intervention. But the first case we tried it was the famous US PNR case, Parliament versus Council and Commission on PNR. And to everybody's surprise and pleasure, the court allowed the intervention. Since then, many interventions, or even now invitations from the court to contribute, have followed. that I didn't know when I applied, but I detected the potential, and I thought, well, let's give it a try. It was extremely complicated. Selection in all kinds of stages, finally a shortlist, and then council and parliament. And the parliament were interrogating candidates about things which were completely outside EDPS. And when finally a decision, after a year and a half of struggling, was made, I remember that in the first meetings with other parts of the commission, that is not internal market, then it was internal market being responsible, they said, what the hell is data protection? What is your role? So I had to explain in parliament, to members of parliament, why the EDPS needed a budget, because there was no budget. There was nothing. So we started to develop this from scratch. And my famous elevator pitch from level 3 to level 11 in the parliament, when the rapporteur on the other institution said, oh, that sounds reasonable, I'm going to support you. That's how it started. But we realized supervision, and I had had some experience with supervision for more than 12 years, consultation, which I'd done for a while, and the commission was extremely welcoming. And I suggested that we should help them think in informal ways and praise their courage and criticize the lack of courage and move to the public part and so forth and so on. All that developed while we were doing it. And of course, with the help of a growing staff. Very small in the beginning, and when I left, 50 or 60, and they have a multiple staff now.
I think indeed it's impressive how you have also put the EDPS in its position, and your successes as well, of course. I think for the interventions in court hearings, that's indeed an important achievement. And I think Hilke Heijmans should be mentioned as well, who was one of the early day employees of the EDPS.
He was one of the very first, yes, and key person in the advisory, in the policy sector.
What I realized when listening to you, but also going again through your whole career, that you have always been active in new areas, of course, or a new area, constantly under development, but also new institutions. So a new committee or a new convention, but a new data protection authority, which was rebranded, and you were in charge. The Article 29 working party in early days, the first EDPS. Is it something you particularly like, to be put in a situation where everything has to be either built from scratch or to be sort of reshuffled in a way that it actually works? And
it's interesting. I've wondered, and at some point we discovered, but it was still in the Dutch Ministry of Justice, that in the legislation department, many colleagues had a sort of a physics, mathematics, chemistry, etc., a empiric and structural, analytical background, and I like dealing with new issues. That's true, but maybe my early experience in the US, which is where the law is very much based on empirical development, and not thinking from principles down, but bottom up, and the like and so forth. I don't know, but this is the way it happened, and it was fascinating to be part of this. And I should add that, mentioned it in passing, but over the years, I've been back to my alma mater in the US, Michigan, a number of times, but multiple times in Washington to give some public advocacy, but also informal missionary work behind the screens. And this was also in the 90s, when Clinton and Gore were discovering the virtue of self-regulation and thought that should be something to deal with the interest of US citizens, to protect their interests. We were actually like missionaries, and there's Ulf Bruhanek spending, campaigning, as it were, to explain what we were doing. And they were not just, oh, those Europeans doing silly things. No, they were extremely interested. And of course, also a bit concerned about the impact. And the directive and transborder data flow surely acted as a trigger, and in the GDPR case, the extraterritorial effects, and what we now refer to as the Brussels effect in general, played a huge role in disciplining. It was fantastic to be part of that.
Was there ever a moment that technological developments moved so quickly or in a certain direction that you thought, I don't know whether data protection can still manage this, or like these recent developments like blockchain at a certain moment and now artificial intelligence? Or do you always keep faith in the value of these rules?
I need to be frank. There are now issues where I am inclined to think, okay, let others do the work now. And I'm following developments, but I don't follow all the details. AI is a bit across the line for me. I know what it is about, but what is ahead is indeed for others. But I'm a firm believer in that's sort of the pragmatic. Don't be fundamentalist. You need to be a principled pragmatist. That is, see how you can realize principles in practice and learn from this. Learn from how it's working. Change where necessary. Be on the alert. So in all those new areas, I would not take it for granted, but build in virtuous circles of learning, testing, and evaluation, go back, etc. And it becomes difficult with AI, where actually the developers don't know themselves what they are actually, at least to some extent.
Thank you very much. We have to approach the conclusion of this interview, unless you have some urgent questions. I hope that the audience, that many people here in Brussels, we know you as the EDPS, the former EDPS, and now that they will have a broader picture. Is there still anything that you want to highlight from this broader picture? When you looking back at your career, I think that really what I get is that this moment where you went to the United States, you listened to Arthur Miller live, and I think that was something that really changed your life.
It did. Yes. Of course, I know that Arthur Miller was not the first. Alan Westin was actually more important, also because he framed privacy as the right to determine. But in the US, the claim to determine. He didn't say the right. Huh? He spoke about a claim, which is crucially different. No, I'm still following, as I said, and a few times a year I am facing master's students in international privacy law from all over the world, and I like to discuss with them in the American sense. What if we change this? What do you think? And that is still fantastic.
Excellent. With this, then I think we can conclude the interview for today. Thank you very much, both of you, for this discussion. And unless you want to add something, and I just say to the audience that there will be another episode of this oral history of data protection law. What this will be about, we will discover this. Just follow the newsletter of the EDPS and see you next time. Thank you.